Guess it's just you and me, Miss Bridgewater.
You good, Judge?
I am. Yeah, you can hear me?
I can.
Okay, yeah, we're good.
Okay, very good. You need anything?
I don't. I need to come up here more often.
And visit, yes, you do. And on those waivers, I do have them already.
Thank you.
Thank you.
Ms. Kim,
Yes.
are both these waivers yours?
Yes, Your Honor.
Why don't we go ahead and do those while we're waiting for the rest of the jail to get out? Oh, no, here
Yes.
they go. Okay,
Oh,
here
okay.
they go already. So, all right, good afternoon.
Your Honor, we're gonna go with position number 16, Ms. Barbara Williams.
Afternoon, Mr. Trejo. Are you representing Ms. Williams this afternoon?
Let me take a look, Your Honor. I don't believe I represent Ms. Williams. I represent position 1, Terrence Brown, position 2, bound out, but she was going to be one of mine also. Mr. Hill, which is position 3, and then positions 8 and I think that's it.
Your Honor, I represent Mr.
Okay.
Williams.
All right. Ms. Williams. Good afternoon, Ms. Williams. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are doing by video this afternoon. Do you agree to have your case read by video?
Yes, good afternoon.
Good afternoon, ma'am. You've been charged in case 22 CR 007806E with battery family violence. Is there a history, Mr. Howard?
The fifth arrest, 06 theft by receiving. 2001 simple assault, family violence, not prosecuted. That's it.
Good afternoon, Ms. Select.
Good afternoon, Your Honor. On November 14th, officers were dispatched to 595 Boulevard, apartment 206 in Atlanta. Officers spoke with the victim in this case, Mariah Smith. Mariah is spelled M-A-R-I-A-H. Ms. Smith stated that her mother, the defendant, struck her in the head with the chopper, causing bleeding and bruising. Ms. Smith stated that she was at work when she received the call that her mother was at her apartment in a dispute with her sister, Minica, and that's M-I-N-I-C-A. Ms. Smith headed to her apartment and got in between the dispute between her mother and her sister. And at that point, the defendant struck her in the head with the door stopper. The defendant did admit to officers to beating the victim with the door stopper. She said that she meant to hit her on her arms and body, but accidentally hit her in the head. The victim was transported to Grady for treatment. I have in her history that simple assault, family violence out of DeKalb was a conviction. So due to her prior history of violence and the nature of this family violence offense, the state is requesting a $5,000 surety bond, no alcohol, drug, or weapons, no contact with the victim, and stay away from the incident location. Nothing further from the state at this time.
Have you spoken to Mariah Smith regarding this matter?
Yes, Your Honor. Our office has the victim. I'm not sure if she's on or not, if she would like to speak. She has stated to us that she would like contact with her mother, but the state would argue that due to her relationship with her mother, she's not in the best place to make that decision at this time. So the state would reinstate its request for no contact.
Thank you. Ms. Kim?
Yes, Your Honor. Ms. Williams, actually, she does not want to have any contact with Maria Smith. No further contact, and she would like to stay away from their places. She has been totally disrespected, and she feels very hurt, and she does not want to have any more contact while this case is completely resolved. My client is qualified for signature on bond. She is 49 years old, and she's been here for all her life here in Georgia, and she used to work at Grady before. However, for the last 2 months, she was not able to have any employment. She does have college education at DeKalb Technical College. She has a cosmetology license, so she can do a little bit of hairs here and there. However, that is not enough for her. So especially she lost her mother not that long ago, and that has made huge impact on her negatively. She has high blood pressure and diabetes, so she really needs to take care of those medicines right away. So we would like to request for a signature on bond so she can take care of herself physically. And all those charges are very remote, and it was not prosecuted on 21 years ago. And Your Honor, she is qualified for a signature on bond. Thanks.
All right, if Mariah Smith is on the line and would like to address the court, this is your opportunity to do so. You certainly don't have to do so, but if you would like to address the court, now is your opportunity. Okay, nothing being heard. It's going to be a $3,000 signature bond through pretrial, 1-day anger awareness. No further contact with Mariah Smith. Stay away from the Boulevard address, apartment 206, and no drugs, alcohol, or weapons while out on bond. Good luck.
Thanks, Your Honor.
Who do we have next?
Position 8, Mr. Perry.
Yes, Your Honor, and I will be handling Mr. Perry's hearing today.
Good afternoon, Mr. Perry. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Perry, you have been charged in case 22 CR 007801J with loitering and prowling and criminal trespass and driving under the influence of alcohol less safe. Is there a history, Mr. Howard?
2019, I guess he was cited out of the Army for possession of a controlled substance. He went to felony earlier. He got a $30,000 bond on that.
What do you know what he went for?
I see false imprisonment. I'm thinking it's the false imprisonment.
Okay.
And that's it.
Afternoon, Ms.
Well, false imprisonment and battery. So
That's correct. Good afternoon, Your Honor. Your Honor, in this case, the victims whose names are Melissa and Gary Lawhon, that's Lawhon, they were awoken by a stranger yelling and noises, which was the defendant attempting to gain entry into their home. He was attempting to gain entry by force and actively pushing up against the door with his shoulders. One of the victims, Mr. Lawhorn, he got up and actually pushed against the door to prevent this defendant from breaking into his home. And when the defendant could not get inside through the front door, he ran around to the back and continued to try to break in. Mr. Lawhorn, he then drew his gun in an attempt to prevent this defendant from breaking into his home. He did not discharge the firearm. Once officers arrived, they were able to detain the defendant and place him inside the patrol car. He did have vomit all over his clothing and alcohol coming from his breath. And actually, his vehicle was discovered crashed into a parked vehicle. That vehicle did have the keys in the ignitions and the lights on, and the car was still running. Your Honor, as we've heard from pretrial regarding the defendant's false imprisonment and battery open case, this defendant does present a risk of reoffending. He does present a risk of being violent, and all of these events that did occur, they were caught on camera. The state is requesting a $10,000 surety bond. That's with conditions of no contact with the victim, stay away, no driving, and no drugs, alcohol, or weapons. And that breakdown is $5,000 on the DUI, $2,500 on each remaining charge. And the incident location, Your Honor, is 1678 John Calvin Avenue in Atlanta. Nothing further.
If he was arrested on, or if this happened on September 18th, was he not taken into custody at that time?
Your Honor, to my understanding, he was taken into custody. I'm not sure why we.
Or just getting him?
Yeah, correct.
Okay, all right, thank you. Mr. Trejo?
Yes, Your Honor. I don't, first and foremost, Your Honor, I don't think that my client is a flight risk. He has roots here in Atlanta. He's been in Atlanta for about 2 years, and he's lived here since he was discharged from the military in December of 2019, where he served for 3 years in Germany. He's gainfully employed. He has consistent employment with Best Buy, where he's a technician doing installs and things of that nature. And he currently lives with his mother, who's been here for about 10 years. Your Honor, I don't believe that my client is violent. My client doesn't have extensive priors. Everything really is related to this same incident. And then in terms of any risk of violence to the alleged victims, the homeowners in this case, or witness intimidation, Your Honor, this was quite simply, Your Honor, my client didn't have any prior connection with them, had never met them before. It was a mistaken address. And then based on the state that my client was in at the time, I think this could be all attributed to an isolated incident. My client had been at a party earlier that day. And certainly that doesn't excuse his actions. That does give further context that we're not dealing with somebody who's violent here. We're not dealing with somebody who is trying to gain entry into this home to cause harm to whoever was inside. Furthermore, Your Honor, my client is going through some additional, does have some ongoing healthcare needs that we would ask the court to consider when setting the bond. Obviously, our position would be that he would qualify for a signature bond given his ongoing medical needs. He receives Social Security for knee issues that he obtained while he was in the military, and has ongoing physical therapy for that. And he is currently seeking treatment for depression and some other mental health issues, again, in connection with his military service. He currently helps his sister pay bills. He helps his mother pay bills. Like I mentioned, Your Honor, he lives with his mother. Her rent is about $1,800. He pays an estimated $1,000 per month out of that rent, and does also help his girlfriend with some bills, in addition to food and utilities with his mother. So again, Your Honor, just in conclusion, I believe that he's not a serious risk to the community or a flight risk in terms of witness intimidation. Again, this was an isolated incident where I don't believe that he would be intimidating any of the folks that were involved. And then in terms of reoffending, again, as I mentioned prior, Your Honor, I think this was an isolated incident given the circumstances of the offense, and also my client's very limited prior history.
And Your Honor, I would just like you to consider the fact that in this case, he did attempt to gain entry into the home by force. So obviously he was not welcomed, even if he thought he was at the wrong address, and he ran around the back. So he's lucky he was not shot. The homeowners would have been well within their right to shoot him, but they did not. So we would also like you to consider that when making your ruling.
All right. Loitering and prowling is going to be $1,000 good bond. The criminal trespass, $1,000 good bond. The DUI, a $2,000 good bond. A total of a $4,000 good bond. No drugs, alcohol, weapons while out on bond. Stay away from the 1678 John Calvin address, and no further contact with the Lawhorn victims, alleged victims. Good luck to you, Mr. Perry.
Thank you.
Thank you, Your Honor.
Position 10 is next.
Good afternoon, Mr. Porter. I'm Judge Mario. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case read by video?
Yes.
Thank you. You have been charged in case 22 CR 007803G with terrorist threats and acts and simple battery family violence. Is there a history, Mr. Howard?
This ninth arrest. 2018, he was convicted for theft by taking, burglary in the first. He's on probation for 2 different counts of burglary. 2017, entering auto, first offender. 2017, probation. 2017, criminal trespass, obstruction. He had a criminal trespass and obstruction from 2016. Simple battery DB, 2 counts that was dismissed from 2015. And 2014, burglary in the first. That's it.
Ms. Surratt?
Your Honor, I'm also showing a 2016 battery out of Fulton County, but it's with a different victim. On November 7th, 2022, Fairburn police officers were dispatched. Oh, I'm sorry. They spoke with Ms. Vanya Taylor. That's spelled Vonya. Ms. Taylor came into the precinct in order to inform officers about some possible thefts that her son, the defendant, might be involved in. Ms. Taylor then informed officers of an incident that occurred on October 29th, 2022. The defendant threatened to punch her in the face. Ms. Taylor stated that the defendant acted like he was going to hit her and walked by her and pushed into her. Her other son, Marquise, Marquis, Victor, was also present during the incident and did see those actions and hear the defendant make those threats. Ms. Taylor indicated that that she is fearful of the defendant and that she does not want any contact with him, and neither does the witness, Mr. Victor, as well. That simple battery family violence arrest from 2015, the victim in our case, Ms. Vanya Taylor, was the victim in that 2015 simple battery as well. At this time, the state's recommendation is going to be a $4,000 surety bond on the terroristic threats charge and a $3,500 surety bond on the simple battery family violence charge. No alcohol, drugs, or weapons, no contact with Ms. Taylor or Mr. Victor. Stay away from the incident location, which was at 202 McIntosh Court in Fairburn. The state would argue that the defendant poses a risk of reoffending due to his violent history. He's displayed a pattern of violence, specifically against the victim in this case. Due to him being on probation for burglary and having other arrests for property and violence in the community, the state would argue that he is a danger to the community and the property of others as well. And while he has been out on probation, he has been arrested several times. So he's shown a pattern of not following the orders of the court. Nothing further at this time, Your Honor.
Thank you, Ms. Kim.
Yes, Your Honor. Mr. Hugh Poiter is 25 years old, Your Honor. He was born and raised here in Georgia, and he resides with his mother, an older brother, and little sister. Right now, since they are living together, and he expects that he's not going to be allowed to go back to mother's place. I actually asked the social worker services to give him housing resources. He has no children, he's a single, and he has been working at warehouse doing packing for last 3 months. But before that, he did not have any employment. So he does not have much savings at this point. He went to military school, and yet he was locked up when he was 9th grade. So ever since then, that was the highest education that he could get. We would like to request for the signature on bond, and yet understanding the fact that there was some probation issues, we would like to request for maximum $1,000 good bond for each charge, totaling $2,000 good bond. Thanks.
Okay, for the terroristic threats, it's going to be a $2,000 good bond. For the simple battery, a $3,000 good bond, making for a total of a $5,000 good bond. No further contact with Bonya Taylor. Stay away from the McIntosh Court address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. No drugs, no alcohol, and no weapons while out on bond. Good luck to you, sir.
Position 14, Mr. Ware.
Good afternoon, Mr. Ware. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Ware, you've been charged in case 22 CR 007804A with theft by taking. Is there a history, Mr. Howard?
30 total. Last arrest was in July, simple assault, disorderly conduct, PI. 2019 probation violation, 2019 shoplifting NOLO, 2018 trespass NOLO, 2018 giving false name, it was dismissed. 2017 robbery conviction, 2017 theft of lost mislaid property conviction, 2017 shoplifting conviction, 2016 trespass, 2016 shoplifting giving false name conviction, 2011 felony obstruction conviction. I stopped there.
Okay. Yes.
Yes, Your Honor. On November 14th, 2022, Officer Young with the Atlanta Police Department responded to a call at 3155 Roswell Road, Unit 300. Upon arrival, he met with the witness in this case, Mr. Daniel Schaffstall. That's SCHAFSTALL. The defendant was on the scene as well. Mr. Schaffstall stated that when he was coming off of the elevator at the location, he saw the defendant coming out of a room with a pressure washer underneath his hoodie that belonged to the business, which is a parking services business. Mr. Schaffstall advised that he asked the defendant where he was going, and the defendant stated that he was trying to sell some coins at a neighboring business. Mr. Schaffstall then walked after the defendant and told him to stop multiple times. The defendant did not stop, and then the defendant dropped the pressure washer on the ground from under his shirt. At that point, the defendant and the victim, or the witness in this case, did begin to get into a scuffle, in which at that time, Mr. Schaffstall did hit his head on the stairs, which resulted in him getting a cut on the upper right side of his eyebrow. He did decline medical attention, and the defendant was detained at that time. Due to the defendant's history, he's a danger to the property of others. He poses a risk of reoffending. Due to his pattern of theft, I am showing that he does have a July 2022 arrest for simple assault and public indecency out of Clayton County, which he is out on bond for. Due to that, the state is requesting a $3,000 surety bond, no alcohol, drugs, or weapons, and stay away from the incident location. Nothing further at this time.
Ms. Kim?
Yes, Your Honor. Mr. Ware is 39 years old and he was born and raised here in Georgia. He has one child who is 14 and he has not had any employment for the last 6 months. His highest education that he completed is 9th grade. Since he is residentially challenged, I will be asking social worker services to provide housing resources and for him to get BHET evaluated. And we would like to request for signature on bond. And yet, considering the 30 cycles, we would like to request that maximum $1,000 good bond. Even that will be no bond to him. He has no financial means at this point. Thanks, Your Honor.
Ms. Kim, you're requesting of this court an MHET evaluation, is that correct?
Actually, I will start with a BHET, Your Honor, and then if they believe that he is qualified, then we can request for MHET at that time.
Okay, he's going to be, if he doesn't make bond, he's going to be, the state all-purpose calendar that everyone on this calendar will be December 6th. So he will be on the December 6th calendar. If he does not bond out, as I'm giving him $1,000 good bond, please make sure that the public defender that is representing him knows that he was to have a social worker visit and knows that I'm going to expect a report at that time regarding the MHET, okay?
Yes, Your Honor.
Your Honor, and just for the record, that location, that business location is Executive Parking Systems.
Okay, thank you, Ms. Lett. It's going to be $1,000 good bond, social worker visit, no further contact with Shaw Stall, stay away from the Roswell Road number 300 address, the executive parking system, and no drugs, alcohol, or weapons while out on bond. All right, good luck to you, Mr. Ware.
Thank you.
Position 4, Jackson.
Okay, are we gonna take up all of these criminal trespass and loitering and prowling in some type of order, courtroom too?
Are you referring to all the conflicts?
Yes,
We can do those next.
okay, thank you. And I understand that these all arise out of the same occurrence, if I'm not mistaken.
I'm
And,
sorry.
That's correct, Your Honor.
okay, thank you. And is Mr. Jackson represented? Is Ms. McLeod, good afternoon. Are you representing Mr. Jackson?
Good afternoon, Your Honor. I am.
Okay, thank you. Good afternoon, Mr. Jackson. I am Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video? Is that a yes?
Yes.
Okay, thank you. You have been charged in case 22 CR 007814E with criminal trespass and loitering and prowling. Is there a history, Mr. Howard?
17 total. Last arrest was in July for burglary, criminal damage to property, 2nd degree, theft by taking, possession of tools, conspiracy to commit a felony. That's open out of Cherokee. Open case in Fulton for possession of a controlled substance. 2 counts. 2 counts of possession of a Schedule 4. 1 count of obstruction, possession of a firearm during the commission, possession of a firearm by a convicted felon, a felony first offender. It's 22 CP 209883. Man, on probation for possession of a firearm by a convicted felon, a felony first offender, theft by a receiver, criminal damage to property, 2nd degree. That's 18 SC 162523. He got a probation hold too. Well, it says probation on the booking sheet. That's pretty much it. Because in the history, well, he got a robbery conviction from 2010 out of Cobb County. But most of the history is what I read off the bond assessment, the open case and the probations. Nothing further.
Thank you. Who's presenting for the state?
Your Honor, my understanding was going to be Ms. Todd.
Are you with us?
I am, Your Honor. If you'll indulge me 1 second while I pull this position up. Give me 1 moment. And I'm sorry, can you remind me again which position this was? I didn't identify this as one of mine.
This is position 4, Christopher Jackson.
Christopher Jackson, my apologies. So this is one of the ones that does have the other 6 co-defendants that we were just speaking of. This is officers were called out to the address of 3326 Delmar Lane Northwest. Upon arrival to the home, the officers did encounter Mr. Jackson's co-defendant, Mitchell Hill, outside of the home. When the officers attempted to speak to co-defendant Hill, he immediately turned and ran back into the home. The officers surrounded the home both by the front and back door and attempted to enter the home to discover that both doors had been locked. The officers further announced their presence over the patrol car's loudspeakers, asking the occupants to all come out. However, there was no response. The officers did make contact with the construction company listed on the building permit outside of the home. They spoke with a Mr. Hunt Warner, and they were informed that the house was being built for a Mr. Corby Cobb. Mr. Warner and Mr. Cobb both confirmed that no one was supposed to be in the house at the time. And Mr. Cobb stated that he did not give anyone permission to be in the home. Officers were able to identify one of the vehicles that was in the driveway as belonging to the father of co-defendant Mitchell Hill. Mitchell Hill's father was able to call his son and convince them, as far as the officers were aware, to exit the home, and that is when all 7 co-defendants exited the home. For Mr. Jackson, we are requesting a $2,500 surety bond on the criminal trespass. We are asking for a stay away and a no contact order for all co-defendants, as well as no alcohol, drugs, or weapons. For the loitering or prowling charge, we are also asking for a $2,500 surety bond and a stay away from Mr. Corby Cobb's home at 3326 Delmar Lane for a total of $5,000 surety bond. As pretrial stated, there is kind of a significant criminal history in this case, so we are concerned of risk of reoffending. We are aware of an open case for burglary, criminal damage to property, and theft by taking out of Cherokee County.
Okay, Ms. McLeod.
Yes, Your Honor, my client is 36 years old. He is a native of Atlanta. He tells me that he has 10 children. They range in ages from 18 to 6. He is currently employed, Your Honor, but does not make a lot of money. He tells me at this time, he's living with his grandfather. He works, but as I say, his wages are not very high. He does warehouse work. I understand that he does have some significant history, Your Honor, but in this case, he tells me that he was on his way to work and he saw someone he knew was a friend who invited him to what he thought was his house. So he just stopped briefly, and next thing, the police were there. So, he didn't know, he just thought he was hanging out with a friend who he saw on his way to work, Your Honor. He's not in a position to pay a $5,000 bond, Your Honor, because he doesn't have the money. I would ask the court to take that into consideration in setting a bond for him. Thank you, Your Honor.
All right, it's going to be $1,000 good per charge, making a total of a $2,000 good. Stay away from the Delmar Lane address. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Jackson.
Thank you, Your Honor.
Position 5, Laster.
Good afternoon, Mr. Laster. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 22 CR 007799Y with battery family violence. Is there a history, Mr. Howard?
No.
Ms. Sori?
Yes, Your Honor. In this case, this incident occurred at 50 Mount Zion Road in Atlanta. Officers responded regarding a domestic dispute. The victim in this case, her name is Neferteria, Nefertearia, last name Newton. She informed officers that she and the defendant got into an argument over her not allowing the defendant to come with her to a temporary agency regarding a job. The defendant struck the victim twice in her face, and she is, per the report, currently expecting around 3 months. So that injury did, battery did result in injury to this victim. As a result, the state is recommending a $4,000 surety bond. Stay away from the incident location, 1 day anger awareness, no contact with the victim, and no drugs, alcohol, or weapons. Your Honor, this incident did occur around 7 p.m. yesterday. So the state would argue that there has not been adequate cooling off period, and he does present a risk of intimidating this victim as she is currently pregnant. Nothing further.
Thank you. Mr. Pound?
Yes, Your Honor. I believe that Miss Newton should be on the Zoom. I spoke with her and she told me that she would.
Yes,
Okay.
hello?
Yes, hold on, Ms. Newton. I will give you the opportunity to speak in just a moment. Yes, she is, Ms. McLeod. Would you like her to speak prior to your?
Yes, I would like her to speak before I
Okay.
go, Your Honor.
Okay, that's fine. Ms. Newton, if you would like to address the court, I'll need for you to unmute yourself, activate your camera, and I'll have to swear you in, okay?
Yes, my camera doesn't work at the time.
Okay, I'm gonna have to have you on camera. Do you have, is it not working or you just cannot get it to work?
Oh, there you go. Yes,
Very good. Can you raise your right hand for me? Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
yes.
Okay, you can put your hand down, ma'am. What would you like to tell the court?
It's nothing really. I'm not. So they was like, "Am I scared of him or something?" I'm not scared of him. Nothing like that. It was our first argument. It wasn't really nothing out of like that meant to go that far.
This hasn't happened before?
No, it hasn't.
How far are you along, ma'am?
I'm just 3 months. That's all.
All right.
And I still want him to be around for his child. I didn't sign no what's that called? I forgot what it's called. I didn't sign nothing so he can't be around me. I didn't sign no papers on that. I still want him to be around for his child.
Okay. Is this your first child together?
Yes.
All right. Anything further, ma'am?
No, that's all.
And I'm sorry, Your Honor, before anything, could you have the victim go into a lighted room so we can see her face?
Do you have the ability to turn on the light, Ms. Newton?
Really, okay, yes.
All right, there you go. Thank you, Ms. Newton. Anything further, Ms. Sally?
No, sir. That'll be all.
Your Honor, I would wait for Ms. McLeod to finish.
Okay, Ms. McLeod?
Your Honor, my client is 21 years old. He's a native of Atlanta. He tells me that he and Miss Newton share a 3-year-old, and they are also expecting another baby. And she also stated that. He said that they were just having a verbal argument, and it got a little loud and they think someone, maybe a neighbor, called the police. But he denies that he struck Miss Newton. He just says that their dispute was a verbal dispute. He doesn't have a record, Your Honor, and he's just 21 years old. So I would ask the court to consider giving him a signature bond so that he can get out of jail. He does want to continue to have contact with Miss Newton and their minor child, Your Honor. And I would ask the court not to prevent him from doing so, because I did have the opportunity to speak with her before I came on, and she assures me that she does want to have contact with him and for him to have contact with his child. Nothing further, Your Honor.
Thank you. Ms.
And I'm
Todd?
sorry, yes, Your Honor, as the report does state that the victim sustained bruises and marks to her face, I would again ask that the victim go into some light so we can see her face, please.
I believe she did that earlier, and I don't have the best eyes in the world, but I didn't see any injuries to her face.
I believe, I mean, you had the opportunity when she was on camera, Ms. Newton, Ms. Sari. I did see her, her face when she came into the light. Anything further?
Nothing further, Judge.
All right, it's gonna be a $3,000 signature bond through pretrial, 1-day anger awareness, no further violent contact with Ms. Newton, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Laster.
Thank you, Your Honor. Your Honor, that concludes my business before the court today. May I be excused?
Yes, have a good day, Ms. McLeod. Thank you.
Thank you. Thank
You
you.
said, how much was that, 3,000?
That's correct, yes.
Position 13, Stevens. All the rest of these cases are going to be conflicts, Judge.
Okay.
Get down, man.
And are any, is the public defender representing any of these cases?
Not for all the rest of the conflicts.
Okay, all right. This is Mr. Stevens.
Yes.
Good afternoon, Mr. Stevens. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Stevens, you have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. Unfortunately, because of the number of you in this incident, we were unable to get representation for you today with conflicts attorneys. You have the option of either proceeding pro se today, which means without the advice of counsel, or you can wait until tomorrow when we can get an attorney to assist you. Which would you prefer?
Okay.
Say it again?
Okay.
Okay, very good. Is there a history, Mr. Howard?
20 total. History out of Georgia and Texas. Texas, he got a possession of a firearm by a felon. That was a conviction, 2009. Last arrest in Georgia, 2019, suspended license. I see a 2019 battery DV, cruelty in the second degree arrest. 2014 battery DV arrest. 2012 probation, underlying charge was 2 counts of burglary. Possession of cocaine and battery conviction from 06. He's wanted out of Canton for burglary from the looks of it.
All right, thank you. Ms. Todd, anything to add as far as the facts go? And I'll take your bond recommendation.
As far as the facts, no, Your Honor, our bond recommendation is going to be a $2,500 surety bond on the criminal trespass. That's going to include orders for stay away, no contact with the other co-defendants, no alcohol, drugs, or weapons, and as well as a $2,500 bond for the loitering and prowling with the conditions of stay away and no alcohol, drugs, or weapons. Our concern is his risk of reoffending in this when he does have a criminal conviction for criminal trespass. He has 2 prior arrests for criminal trespass, as well as a couple of theft convictions and the open warrant out of Canton.
Okay, thank you. It's going to be a $1,000 good bond on each charge, making for a total of a $2,000 good bond. Stay away from the Delmar Lane address. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Stevens.
Thank you.
You're welcome.
Position 18, Michael Young.
Good afternoon, Mr. Young. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Okay, thank you, Mr. Young. You also have been charged in case 22 CR 007811E with criminal trespass and loitering and prowling. You also have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. As I told the other young man, we do not have, because of the number of people here today on this one matter, there is not enough representation for today. If you would like to wait until tomorrow that we can get someone for you, we're happy to do that. If you would like to proceed pro se, we can proceed pro se. Which would you like to do? Say it again.
I'd like to continue.
Okay, very good. Thank you, Mr. Young. Is there a history, Mr. Howard?
26 total. Last arrest was in July, probation violation out of Forsyth. January probation. He's on probation for felony theft by taking, violation of Georgia RICO Act. 2012, I'm sorry, theft by taking, felony. Oh, yeah, okay, that's the RICO Act. Huh? It was also a burglary with that arrest. I'm not sure what happened with it. 2011, driving without a valid license. Probation for ag assault in 05, which came off a 04 case. That's it.
Do you have the same bond recommendation, Ms. Todd?
Yes, we do, Your Honor.
Okay. It's going to be $1,000 good bond on each charge, making for a total of a $2,000 good bond. Stay away from the Delmar Lane address and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Young.
Position 6, Lewis.
Good afternoon, Ms. Lewis. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. You have been charged in case 22 CR 007813E with criminal trespass and loitering and prowling also. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present to represent you. Again, we do not have an attorney to represent you today, so you can either wait until tomorrow for representation, or you can proceed pro se today, meaning without the advice of a lawyer. What would you like to do?
Pro se today.
Okay, very good. Is there a history, Mr. Howard?
It's a fourth arrest. Last arrest was 2004, theft by taking.
Is there a reason that she wasn't recommended?
They said on here she had a hold. It looks like it's out of Ohio, though. Lindale Village, Ohio. I don't know if they're coming or anything, but that's what the recommendation was.
All right, Ms. Todd?
It would have been SOB jail anyway, though, Judge.
Okay. Ms. Todd?
For this case, Your Honor, it is going to be the same recommendation as the previous ones. $2,500 surety, stay away, no contact with the other co-defendants, as well as no alcohol, drugs, or weapons for the criminal trespass, and the $2,500 surety bond, as well as a stay away condition and no alcohol, drugs, or weapons for a total of $5,000.
All right, Ms. Lewis, since you don't have a significant criminal history, I'm going to allow you to sign your own bond. So it's going to be $1,000 signature bond on each charge, which makes for a $2,000 signature bond through the jail. Stay away from the Delmar Lane address and no drugs, alcohol, or weapons while out on bond. Although I'm going to let you sign yourself out, you have to make sure that you come back for your next hearing on this matter. Otherwise, they'll put a bench warrant out for you, okay?
Perfect. Thank you.
All right, have a good day, man.
Thank you.
Position 11, Sloan.
Good afternoon, Mr. Sloan. You also have been charged in case 22 CR 007812E with criminal trespass and loitering and prowling. Let's see, we're doing this by video this afternoon. Do you agree to have your case heard by video?
Yes.
Thank you. We also do not have a lawyer to represent you this afternoon. As such, you can either wait for it until tomorrow, or you can proceed today pro se without the advice of a lawyer. What would you like to do?
Proceed today.
Okay. Is there a history, Mr. Howard?
15 total between Georgia and South Carolina. Last arrest was October 3rd, shoplifting out of Cobb. 2014, given false name conviction. 2011, battery, dead docket. 2010, he got first offender for possession of tools, burglary, and theft by taking. Before that was 09, trespass. 08, interference with government property not presented to the grand jury. Everything else is old.
All right, Mr. Howard, I'm sorry. What was the last, the most recent
Arrest,
arrest?
October 3rd, shoplifting out of Cobb.
What was the most recent conviction?
2014, given false name
Okay,
out of Gwinnett.
all right. Ms. Todd, are there any changes to your recommendation?
No, Your Honor, no changes.
Okay. Because of the limited criminal history, Mr. Sloan, I'm going to also allow you to sign your own bond. As such, it'll be $1,000 signature bond through the jail on both charges, makes for a total of a $2,000 signature bond through the jail. Stay away from the Delmar Lane address and no drugs, alcohol, or weapons while out on bond. I will also advise you that you'll need to show up for your next hearing date, and if you don't show up, they'll put a bench warrant out for you. Okay.
All right, thank you, sir.
You're welcome. Good luck, Mr. Sloan.
Thanks, sir.
Position 17, Herman Young.
There was a Michael Young and a Herman Young. Have we? Okay, so this
Herman Young, Judge.
is Herman Young. Okay. Again, good afternoon. I'm Judge Eric Morrow. This is a state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video? Was that a yes?
Yes, sir.
Okay. Mr. Young, you've been charged in case 22 CR 007811E with criminal trespass and loitering and prowling. Also, again, we do not have an attorney to represent you this afternoon. You also have a right to remain silent, and anything you say can be used against you. If you would like to go ahead with the matter today and proceed pro se, we can do that. If you would like to wait until tomorrow until we can have an attorney present, I'm happy to do that also. What would you like to do?
Go ahead with it.
Okay. Is there a history, Mr. Howard?
30 total. Last arrest was theft by taking conviction, 2019. 2019, possession of cocaine, possession of drug-related objects, arrest. Before that was 2013, possession of cocaine, abandonment of dangerous certain drugs. 2013, probation for shoplifting. The probation was not prosecuted. 2012, probation, 2012, shoplifting conviction. Another 2012, arrest for shoplifting. And before that was 07, FTA for terroristic threats, not prosecuted.
All right. What, I'm sorry, when was the last conviction?
Theft by taking, 2019,
2019.
misdemeanor. Theft by taking.
Any further, Ms. Todd?
Same recommendations, Your Honor.
Okay. Mr. Young, it's going to be a $1,000 signature bond through the jail on both charges, making for a total of a $2,000 signature bond through the jail. Stay away from the Delmar Lane address. No drugs, alcohol, or weapons while out on bond. Although I'm letting you sign your own bond, Mr. Young, you'll have to make sure that you return for your next hearing date. Otherwise, I'll put an arrest warrant out for you. Okay.
All right.
All right. Good luck to you, sir.
Thank you.
Position 1, Brown.
Afternoon, Your Honor. I'll be handling this one on behalf of Mr. Brown.
Okay. Thank you, Mr. Trejo.
Yes, sir.
Mr. Brown, good afternoon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Okay, thank you. You have been charged in case 22 CR 007797D with battery, family violence, and criminal trespass. Is there a history, Mr. Howard?
10 total. I got a 2012 arrest out of Massachusetts, assault and battery. I got a simple assault, harassment, another simple assault, another harassment. This was out of Pennsylvania from 2014. DUI 2014 out of Pennsylvania. Criminal mischief, causing or risking catastrophe, arson related charges. That was 03 out of Pennsylvania. As far as Georgia, let's see. 2020, terroristic threats. That was dismissed. It was a robbery by sudden snatch with that arrest as well. I'm not sure that one was dismissed. I didn't see the disposition. 2019, theft by receiving, giving false name. First offender for those. 2016, aggravated assault, PTI dead docket. And suspended license from 2016 and a failure to appear. That's it.
Ms. Sally?
Yes, Your Honor. This incident took place at 2227 Bigwood Trail in South Fulton. The victim in this case, whose name is Dion Henderson, she called 911, and when officers arrived, she informed them that she and the defendant were in a verbal argument when he suddenly punched her in the face and pushed her onto a sofa. The victim, she tried to run outside after the defendant did this, but he grabbed her by the jacket to prevent her from leaving. She was eventually able to get free, and she ran to a neighbor's home for help, and she did sustain a lump on her forehead. Once the victim ran out, the defendant followed behind her and told her to get inside or he would punch her again. And then he proceeded to punch the window of her vehicle, and that caused it to shatter. And he did flee before officers arrived. Your Honor, as we've heard from pretrial regarding this defendant's history, he did have a 2020 terroristic threat robbery charge that was dismissed. However, he did have a 2016 ag assault against the same victim. In that case, he cut her with a box cutter, and it was dead docketed because he successfully completed the pretrial program. So it was against this very same victim, Your Honor. He does present a risk of reoffending and presenting a risk of violence and intimidating this victim. He is a multi-state offender, so the state's recommendation in this case is a $10,000 surety bond, $4,000 on the battery family violence, $1,000 on the criminal trespass, and we are it's currently a $10,000 surety, but we're recommending the $5,000. No contact with the victim, stay away, 1-day anger awareness, and no drugs, alcohol, or weapons. Nothing further.
Has your office spoken with Dion Henderson?
We have spoken with her. She stated that she and the defendant are no longer together, and that he did pay for her window. And she also stated that she did not want to pursue the charges. However, the state is going forward with our prosecutorial discretion. He had 2 cases against her, and although it's remote, it doesn't negate the fact that there's violence on this victim twice.
And this is from November of 2020, is that right?
That's correct, Your Honor.
Thank you. Mr. Trejo?
Yes, Your Honor. Just to address the likelihood of my client reoffending, again, I would just ask the court to consider that this case is 2.5 years old, and some of those other more recent cases that may have involved the alleged victim in this case were resolved by other means. Either they weren't pursued or they were dead docketed for my client's compliance with pretrial intervention or other types of programs. Prior to that, Your Honor, the ones that were fully adjudicated are significantly old and predate my client moving to the state of Georgia. My client is 33 years old. He's been in Georgia for about 10 years at this time. He is gainfully employed. We don't believe that he is a flight risk, Your Honor. Not only does he have family in the area, but he also has a mortgage. The alleged victim in this case, they no longer have any. They're in a much, as the way my client put it is, Your Honor, they're in a much better place than they were 2 years ago. He even helps pay tuition for her son, who's currently enrolled at Savannah State. Not only is he gainfully employed at Popeyes, where he's been working for 2 years, but he has other employment in the city that keeps him busy. In terms of other ties to the community, Your Honor, he has family here. We don't believe that he's at risk of reoffending again. Any other cases with her are older and were disposed of by other means, and he hasn't had any history since this offense, Your Honor. We don't believe he's a threat to the community. We also don't think that he's at risk of intimidating this witness, given their more recent history.
And Your Honor, our victim advocate spoke with the victim. She told our office that she and the defendant are no longer in contact. However, we've just heard from the defense that there still appears to be some contact. So that does indicate a risk of intimidating this victim. She's no longer even wanting to pursue them and stating that she doesn't communicate with him. So we do have some concerns regarding the intimidation.
Well, Your Honor, we would just ask that. I mean, we would have no issue with a condition being no further violent contact with the alleged victim. But again, based on what the state is saying about their conversations with her, I don't believe that the next logical conclusion of the current state of their relationship, if any, is that he's a risk to her or to others.
All right, for the battery family violence, it's going to be a $4,000 signature bond through the jail. For the criminal trespass, $1,000 signature bond through the jail, making for a total of a $5,000 signature bond through the jail. No further violent contact with Dion Henderson, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Brown.
Thank you, Your Honor.
Position 3, Mr. Hill.
And I'll be handling Mr. Hills as well, Your Honor.
Okay. Good afternoon, Mr. Hill. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Hill, you've been charged in case 22 CR 007808E with criminal trespass and loitering and prowling. Is there a history, Mr. Howard?
18 total. Last arrest was in July, failed to appear, suspended license. May, suspended license. Possession of a firearm by convicted felon or felony first offender. Trespass, simple battery from 2020. Another 2020 arrest, simple assault, family violence. Criminal trespass, damage to property. January 2020, failed to appear for trespass, obstruction, simple battery. Came off an 18 CR case. 2019, possession of cocaine, arrest. 2019 FTA for criminal damage to property, second degree, simple battery, trespass. 3 counts of trespass and 1 count of obstruction. And another simple battery. Hold on. I'll give you this open case. You got to open 20 CP. 20 CP 194863. That's the firearm by convicted felon, trespass, and simple battery. It's open and non-complex. I see a 2016 terroristic threats. Probation violation from 2017. Underlying charges: ag assault, terroristic threats, obstruction, simple battery. I also see a theft by taking in his history. I think that's about it. Yeah, that's it.
Anything to add to the facts, Ms. Todd, or the bond recommendation?
Nothing to add to the facts, Your Honor. We are going to stick with our $5,000 total bond recommendation as with the previous co-defendants, especially considering the propensity for risk of reoffending with the several prior arrests and a conviction for criminal trespass in this case.
Mr. Trejo?
Yes, Your Honor. We would ask that that the court consider a signature bond or capping the amount of bond. Even something very low as $1,000 could be cost prohibitive for my client. He's not working. He's a caretaker for his 84-year-old grandmother. He lives with her. He helps her set up her doctor's appointments. He takes her to her appointments up to 3 times a week. She's 84 years old, helps her make sure bills are getting paid and making sure that that she's taking her medication and basically that her life is in order. My client indicated that he's currently looking for work, and our main concern, Your Honor, would be that even as I mentioned previously, even a small bond would be akin to no bond in this case. In terms of witness intimidation, most of his co-defendants are in custody on this matter, Your Honor. In terms of being a threat to the community, I think it's telling that a lot of these cases that he's had previously involve some form of trespassing. I think that my client mentioned that he has other friends who are squatters who are experiencing some housing instability, and I would contend that without knowing the facts of a lot of those other cases, that would be the source of them. And then in terms of being a flight risk, Your Honor, my client has been here 32 years. He's born and raised in Atlanta, and the court has ways of keeping tabs on him. So I don't believe that he would be a significant flight risk.
Okay, as with the other cases where there has been significant history, it's going to be $1,000 good bond for each charge, which makes for a total of a $2,000 good bond. Stay away from the Delmar Lane address, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Hill.
Thank you, Your Honor.
All right, is that is complete courtroom? Everyone in courtroom 2 today?
No, we have one more position 12, Mr. Smith.
Okay, thank you. Good afternoon, Mr. Smith. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Smith, you've been charged in case 22 CR 007807B with death by taking. Is there a history, Mr. Howard?
7 total. Last arrest was November 1st. Obstruction. I see a case out of Clayton County for criminal trespass, shoplifting and obstruction, on probation for obstruction out of state court. It's 22 CR 007577B. 2013 shoplifting arrest. 2021 entering auto, that was dismissed. And everything else I already talked about. That's it.
All right, Ms. Surratt.
Your Honor, that 2022 obstruction conviction, he was placed on probation on November 10th of this year by Judge Law. On November 14th, 2022, officers with the Atlanta Police Department were dispatched to a theft call at 517 Main Street in Atlanta. Upon arrival, officers met with the victim, Akeem Whitaker, that's A-K-E-E-M, last name Whitaker, W-H-I-T-T-A-K-E-R. He advised that an unknown male stole his Ring camera off of his front door and that the defendant was still on the property. The victim did provide video of the incident to officers, and the defendant was later identified as Sebastian Smith. Due to the defendant currently being on probation and committing a new offense 4 days later, his prior arrests as well have to do with property crime. So the state would argue that he poses a risk of reoffending, and he's also a danger to the community and the property of others. The state's recommendation at this time is going to be a $1,500 surety bond, no alcohol, drugs, or weapon while out on bond, no contact with the victim, Akeem Whitaker, and stay away from the incident location at 517 Main Street.
Okay, thank you, Ms. Kim.
Yes, Your Honor, Mr. Smith is 30 years old. He is Atlanta native. He does not have any children. He's single, and yet he has a parents and brother and sister. The families reside here. However, nobody's going to be able to help him with a bond. He was really excited to start his new job at the fast food restaurant today. However, he cannot start yet. And he really want to go back and start the job that he recently got. He graduated from high school with a GPA 3.2, and he does have some college credit from Atlanta Technical College. And also he served in the Army from 2010 to 2016. He was discharged with honor as an E4 specialist. He claims that he was just picking up Halloween stickers, and this is complete misunderstanding as stealing something he was not stealing. Your Honor, I have not had a chance to review any of those video that solicitor was mentioning about, so we would like to request for signature on bond for his case, and that's it, Your Honor. Thanks.
Okay, it's going to be a $5,000 signature bond through the jail. No further contact with Akeem Whitaker. Stay away from the 517 Main Street address, and no drugs, alcohol, or weapons while out on bond. Mr. Smith, I'm giving you the opportunity to sign yourself out, but if you don't show up for your next hearing date, they're going to put a warrant out for you, okay? All right, good luck to you, sir.
Judge Morrow, I got a quick announcement.
Yes.
Position 2 bonded out.
Okay.
Position 7 waived their appearance.
Okay.
Position 9 is a medical reset. And that's it, Judge. We're
All
completed.
right. Thank you. Y'all have a good afternoon. I appreciate it.
Thank you. You do the same, Judge Morrow.
Your Honor, if I may,
Yes.
it was our understanding that there was also supposed to be a Carlton Burns, case number 22 CR 007816, on today's bond calendar.
Judge Morrow, he's
Yes.
not on our calendar for today,
Yeah, I ain't have him on the pool sheet either.
and he was not on our call sheet as well.
Okay, so he's not on my calendar either, so I guess if he is still in custody, he'll be on tomorrow's calendar. Okay?
And what
And
happened with
I'm sorry,
Navy?
what did you say, Judge Morrow?
I said if he's still in custody, I guess he'll be on tomorrow's calendar. Right? Okay? All right. Yes, y'all have a good afternoon.
Judge, I got a question. What happened with whoever's first name was Navy, last name started with an O? That was on the pool sheet, so that's why I'm asking.
Okay, that wasn't on my calendar also either, Mr. Howard.
Find it out.
He bonded
Yes,
out.
he bonded
Okay,
out.
thank you.
And so we've got 2 waivers to do, and we have, who's at the South Annex?
Good afternoon, Your Honor. Before you is position 15, Ms. Warrior.
Good afternoon, Ms. Warrior. I am Judge Eric Morrow. This is a state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. You have been charged in case 22 CR 007805B with battery, family violence, and 2 counts of cruelty to children in the 3rd degree. Is there a question, Mr. Howard?
Nope.
Ms. Saleh?
Your Honor, on November 14th, 2022, officers were dispatched to 3640 South Fulton Avenue. Upon arrival, officers met with the defendant and the victim in this case, Mr. Desmond Roberts. Mr. Roberts stated that he and the defendant went out for a date night. However, when they returned back to the home, the defendant began accusing him of looking at another female and started beating him. While officers were talking with the defendant, they could smell a strong odor of alcoholic beverage on her breath. Officers noticed on the victim's face area scratches and bruises on his face, chest, and on his in his armpit area. There were also 2 juveniles present, or they could hear the actual incident happen in their bedroom. The juveniles that were present are the victim's niece and nephew. At this time, we only have their first names, and those initials are R and M. So that's why we have the 2 cruelty to children in the 3rd degree charges. At this time, the state is requesting a $3,000 surety bond on the battery family violence charge and a $1,000 surety bond on each of the cruelty to children in the 3rd degree charges. The state is aware that the defendant does not have any prior criminal arrests, but due to the nature of the charges, the state would argue that the defendant poses a risk of reoffending. The defendant and the victim have been in a relationship for about 2 years, and they do currently live together. So the state would be asking for no contact with the victims and to stay away from the incident location, no alcohol, drugs, or weapons while out on bond.
Ms. Saleh, has your office spoken with Mr. Roberts?
I do not believe our office has made contact with the victim in this case.
Thank you. Ms. Kim?
Yes, Your Honor. Miss Warrior is 33 years old, Your Honor, and they have lived together, and the place is actually belong to Mr. Roberts. So my client understands that there might be a stay away from that incident location, and she does not object to that one. No further contact is okay. We have no objection. There is a child who is only 15 months. They are the child of Mr. Roberts and Miss Warrior. She wants to make sure that she has a custody. I mean, she can have a visit to 15-month-old child. She has been here in Georgia ever since from 1998. She also has another child who is 8 years old. So those 2 children are the very one that she will never leave here in Georgia. She has an employment as a bartender. She's been working as a bartender for the last 12 years, and she graduated from high school successfully. She has some college education at Clayton State University. She does have a little bit of a postpartum depression because of giving a birth. It has not been that long. She's still going through the breastfeeding, and because of that, she's not able to sleep well. There's insomnia going on. So there's a lot of factors of biological factors that she's impacted by the hormones. I would like to request for signature on bond because she is qualified for unsecured judicial relief, and this is her first offense, and she really loves her children. And we didn't know anything about cruelty to children charges. There was only one, which was battery for family violence, and we would like to request for signature bond for all of them. Thank you.
And Your Honor, the state is not asking that she have no contact with her child. It was the niece and nephew of the victim, and the state would be unopposed to third-party contact or third-party contact in reference to their child that they share.
Okay. For the battery family violence, it's going to be a $3,000 signature bond through pretrial. For the cruelty to children, $1,000 signature bond each through pretrial, making it for a total of a $5,000 signature bond through pretrial. 1 day anger awareness, no further contact at this time with Mr. Roberts. Stay away from the South Fulton Avenue address. She can, of course, have contact with her child. There will have to be third-party transfer for visitation of the child, and no drugs, alcohol, or weapons while out on bond. All right.
Your Honor, may I please clarify one thing? Is it 1,000 per each?
Yes, it's
Cruelty to-
5,000. Yes, it's $5,000 signature bond total through pretrial, 3, 1, and 1.
Okay, so first one was a $3,000.
Battery family violence is a $3,000 signature bond. Cruelty to children, the first one's a $1,000 signature bond. Cruelty to children, the second one's a $1,000 signature bond. Makes for a total of a $5,000 signature bond.
Thank you, Your Honor.
Okay?
Thanks.
Yes.
I'm sorry, Judge Morrow. I was asking, somebody wants to know about position 7 North. I know they waived their appearance, but we have a visitor
Yes.
out in the front lobby is requesting, they're wanting to know what her bond was. I'm not sure if you guys did her yet.
No, we haven't gotten there yet. I think we have 2 waivers that we still need to do.
Okay.
Okay, so we'll do that now. Are we ready to do position 7 Frederick North?
Yes, I do, Your Honor.
Okay, this is a theft by shoplifting. Is there a history, Mr. Howard?
Okay, well, whoever it is, North, they're gonna do her,
18 total. Only one arrest in the last 20 years, which was 2012, possession of drug-related objects. Before that was 03 FTA. That's it.
All right, Ms. Sari?
Yes, Your Honor. There's currently a $1,000 surety bond on this case. The state will consent to a $3,000 signature bond through pretrial. In this case at CVS located at 2237 Cascade Road in Atlanta. The defendant came into the store and he stole around 14 bags of chips. So given the defendant's history, the state would consent to a $3,000 signature bond through pretrial, stay away from the incident location, and no drugs, alcohol, or weapons.
All right, so it's going to be $1,000 signature bond through the jail, stay away from the CVS, and no drugs, alcohol, or weapons while out on bond. Does that suit you, Ms. Kim?
Yes, Your Honor. Thank you.
Okay,
1,000 signature bond through the jail.
that's correct, yes.
Thanks, Judge.
You're welcome.
They
And I think,
don't have no more files.
okay, are we, I was told that position 9 was going to be a waiver. Is it a waiver? Is it a?
Yes.
All right, so that is Ramon Pierce, position number 9, charged with simple battery. Mr. Howard, possibly Ms. Sari has the history to help.
Your Honor, actually, I was about to request breakout room for mental health issue for this case. The position number 9, Pierce Ramon.
And Your Honor, I thought someone mentioned from the jail it's a medical reset for this position.
She's filed a waiver. Ms. Kim has filed a waiver of appearance, so as such, we can proceed with it today.
Understood, Your Honor.
Thank you.
And given that there's no one else in the courtroom, we're going to proceed this afternoon with bond hearing on the record. So, Ms. Sari, go ahead.
Yes, Your Honor. As far as the defendant's history, I have a 2018 simple battery. I was not able to find the disposition on that. This incident took place at 3393 Peachtree Street in Atlanta. The defendant in this case, he punched the victim whose name is Long Feng, F-E-N-G, and last name Yang, Y-A-N-G, in the face in the presence of officers. Your Honor, there is a bond currently set at $1,500 surety. Due to the nature and the defendant punching someone in front of officers, the state is asking for an increase to $3,000 surety. No contact with the victim. no drugs, alcohol, or weapons, and to stay away from the incident location.
When was his last conviction, Ms. Lowry?
I have a 2018 simple battery that I was not able to find a disposition for.
And before
I
that?
got that open, Judge.
Okay. This simple battery is open. And
And the disorderly conduct.
okay, and that's 2018 for disorderly also?
No, that was from October 12th. Both of the cases, arrests come out of Brunswick, so they open in Glenn County.
Oh, okay. Ms. Kim?
Yes, Your Honor. He is 21 years old, and actually our department filed MH eval order and email to Ms. Holly Bridgewater already. He is recommended for MH eval order. He currently has a $1,500 good bond, so we would like to ask that his bond remains the same, and then we reset him to the competency calendar that is coming up this coming Thursday.
Okay, so it's gonna be a $1,500 good bond, an MHET, stay away from the Peachtree Road address, no further contact with Mr. Yang, no drugs, alcohol, weapons while out on bond, and reset to a competency calendar.
Thank you.
Thank you, Your Honor.
Okay. All right, Ms. Bridgewater, I believe that concludes the calendar. So when you're ready for us, we can go over the calendar.
Okay. Once again, the reset date for the SAP calendar is going to be December the 6th. Wow, that sounds weird. December's here already. Wow. Okay. Position number 1 is reset further notice with a $5,000 total SOB through the jail. Position number 2 is reset further notice as the defendant was released. Position 3 is going to the SAP calendar with a $2,000 total good bond. Position 4, SAP calendar with a $2,000 total good bond. Position 5, reset further notice with a $3,000 SOB through pretrial. Position 6, reset further notice with a $2,000 total SOB through the jail. Position 7, reset further notice with a $1,000 SOB through the jail. Position 8, reset to the SAP calendar with a $4,000 total good bond. Position 9 is being reset to the competency calendar for Thursday. I know you said this Thursday, however, I have to double check that to see if that is available. But it's a $1,500 good bond. Position 10 is going to the SAP calendar with a $5,000 total good bond. Position 11 is reset further notice with a $2,000 SOB through the jail. Position 12 reset further notice with a $5,000 SOB through the jail. Position 13 is reset to the SAP calendar with a $2,000 total good bond. Position 14 SAP calendar with a $1,000 good bond. Position 15 is going to be, if I could turn this page, reset further notice with a $5,000 total SOB through pretrial. Position 16 is reset further notice with a $3,000 SOB through pretrial. Position 17, reset further notice with a $2,000 total SOB through the jail. And position 18 is reset to the SAP calendar with a $2,000 total good bond.
Number 5. Did number 5 get anger awareness? Lester?
I will let you know. Let me get to that. Position 5, 1-day anger awareness class.
Thank
you. Okay. And like I said, I have to double check. Do you know for sure that there is a competency calendar this Thursday? Does anybody know that for sure?
I believe that there is.
There is, Ms. Bridgewater. I'm working it.
Okay, well, I'm going to add it to that calendar.
Yes, ma'am.
Okay. Are there any questions, comments, or corrections? Okay, well, there you have it.
Okay, y'all have a good rest of your day. Thank you so much. We'll see you next time.
Thanks, sir.
Okay.
Mr. Trejo, are you with me tomorrow?
Yes, Your Honor. It's a pretty stacked calendar for me.
All right, we'll see you in the morning.
Yes, sir. I'll see you tomorrow. Thank you.